Hello, my name is Tamara Girardi. I'm an English faculty member for virtual learning at Harrisburg Area Community College. I created this video to tell you about the anatomy of a Creative Commons license. Copyright law is in place to protect works from creators around the world and in different media. According to Creative Commons, quote, copyright grants a set of exclusive rights to creators, which means that no one else can copy, distribute, or otherwise use the work in violation of those exclusive rights, end quote. While copyright law is complicated, it's important to note that once a work is created, it is copyrighted, and permissions must be granted for others to use that content. That's where Creative Commons comes in. Creative Commons licensing allows for flexibility with protections to intellectual property such as copyright, if the creators wish to grant such flexibility. These protections come by way of 4 license elements. Together, these elements create 6 Creative Commons licenses. The first element is included in all 6 licenses. That is the attribution or BY element. Essentially, this means that all content licensed by Creative Commons must be used with attribution to the original creator. The second element is non-commercial or NC. 3 of the licenses include this protection. We will discuss the legal definition of non-commercial a little later. Third is share alike or SA. Under this element of the Creative Commons licenses, creators may only use SA designated materials if they are also willing to share their creations. This element of the licenses encourages continued sharing of content around the world and is included in 2 of the licenses. Fourth, Creative Commons allows for a no derivatives or ND element, which restricts reusers from sharing adaptations of Creative Commons licensed works. The no derivatives restriction is used in 2 of the licenses. Again, these 4 elements combine to create 6 Creative Commons licenses. Let's discuss each one in order of the least restrictive to the most restrictive. License 1. This minimally restrictive license is the Attribution License or CC-BY. Reusers may use this content licensed as attribution for any purpose as long as they give credit. In other words, they may use the content for commercial purposes and/or adapt and modify however they'd like. The only restriction is that attribution to the original work. License 2. Attribution Share Alike or BYSA. Also allows for the same freedoms as the attribution license, but in this case, reusers must be willing to also share their work under the same license. In other words, whatever they create must be shared alike. License 3. Attribution Non-Commercial or BYNC licenses allow for non-commercial uses, again requiring attribution to the creator. According to legal code, non-commercial is defined as, quote, not primarily intended for or directed towards commercial advantage or monetary compensation, end quote. Therefore, anyone can reuse content if they meet that definition, whether the entity itself is commercial, nonprofit, or so on. License 4. Attribution Non-Commercial Share Alike or BYNCSA again allows for non-commercial use as previously defined in the legal code by Creative Commons, but in this instance the reuser must be willing to share their work under the same license. License 5. Attribution No Derivatives or BYND provides some flexibility in use while restricting adaptations. In other words, under this license, reusers cannot make any changes or adaptations to the work, but they can use it for whatever purpose they see fit, even a commercial one. As is the case with all of the licenses, attribution must be present. License 6. Attribution Non-Commercial No Derivatives or BYNCND includes attribution and a restriction that no adaptations may be shared. Additionally, any sharing of the work must be done non-commercially. This is the most restrictive of the 6 Creative Commons licenses. Since two licenses restrict adaptations of content, it's important to discuss what legally qualifies as a derivative. Small changes such as correcting spelling errors or changing formatting of content is not considered an adaptation. On the other hand, combining content with a new medium, for instance adding music to a short video, is considered derivative. If you're planning to adapt a Creative Commons licensed work, it's best to explore this definition in more detail before doing so. That said, this is a good time to note that should a reuser violate terms of a Creative Commons license, the best approach is to correct that violation so that the work meets the license guidelines. Reusers have 30 days from when they become aware of the violation to comply, and if they do so, the license will automatically renew for them. In other words, a violation does not mean that the opportunity to use the content is lost forever. The legal code is essentially the lawyer speak. The legal code specifies the terms and conditions of Creative Commons licenses should they be challenged in court. The non-lawyer language is what you find in the common deeds layer of the licenses. While not quite as formal and expansive, my earlier explanations of the different licenses are similar to the common deeds explanations, in that they're broken down for people to understand more easily. Finally, to help reusers find Creative Commons licensed content through online searches, Creative Commons created machine-readable versions for the licenses. Essentially, this layer is the metadata that software can understand. Remember that Creative Commons licenses work in tandem with copyright protections. However, copyright protections are not in place for all content. Once a work enters the public domain, all of the Creative Commons protections we've discussed no longer apply. Works in the public domain are free to be used by any means. They can be used for commercial purposes and adapted, and attribution is unnecessary. Likewise, Creative Commons licenses do not apply when a reuser's creation falls under the fair use of copyrighted materials. Additionally, Creative Commons licenses do not apply to patents or trademarks. These concepts are certainly complicated, but I hope this video offers a valuable overview of Creative Commons licenses and protections. For more information about Creative Commons licensing, visit creativecommons.org.